Earlier today, the court in Pietermaritzburg struck an application to interdict the traditional coronation off the roll. The two daughters of the first wife of the late King Zwelithini kaZulu wanted to stop President Cyril Ramaphosa's handing over of a certificate of recognition to King MisuZulu's Zwelithini. For more on this, I'm joined by legal analyst Mpumelelo Zikalala. Very good evening to you. Thank you for your time. It was a second application which came to the court after a failed attempt on Friday to get the courts, where, of course, two different parties wanted to get the courts to ensure that the ceremony is interdicted. But that all failed as we saw the coronation getting underway. What did Judge Thomas Ngube have to factor in before he made his decision?
Basically, there were 2 points. The first one is the element of agency. Before you even move to the merits of whether what has brought them to court is supposed to be granted or not. Let's remember, if you bring a matter on an urgent basis, you then say, I want to jump the queue. It is so urgent to such an extent that if I do not get the relief that I'm seeking now, I'm going to suffer irreparable harm in terms of the right that I have. If you don't have or you can't prove that element, then your matter is struck off the roll for the lack of agency. Now, the lack of agency in this case would have been, you knew a long time ago that this ceremony was going to take place. You didn't place any objections in terms of the applicable legislation, in this case, it's the Coronation and Traditional Leadership Act. So what warrants you to come on an urgent basis the day before, hours before the ceremony is supposed to happen? Another thing which was stated by the submissions which were made to the court was to say the recognition has happened a long time ago. The handing over of the certificate is simply a ceremonious occasion. So what good or what are you going to achieve if you want to stop that particular expert? But before we even get to those merits, their case was thrown out of court simply on the basis that it didn't have the sufficient merits for an urgent application to be heard by the Honorable Court.
What will happen should the applicants insist that they want this matter to be taken further? What processes will need to follow?
It doesn't mean that at the moment that the matter is extinguished. It simply means that they are going to be forced to file their papers in a normal manner, give the other party ample time in order to respond as prescribed by the rules. But you must also look at the type of relief that they are seeking. If the relief that they are seeking is something that has already happened today, meaning that the horse is bolted, there's nothing you can get out of it, I think the matter is going to die a natural death. However, if it links to certain things that can be performed even after, one would make a presumption that they maybe want the recognition of the MisuZulu's to be withdrawn. Then they may have a matter on that one, but they would need maybe to go back and look at their papers again and say, we are drafting these papers not on an urgent basis now. Let's add the points that we think are going to draw the attention of the courts, but most importantly, state the case of why the withdrawal should be there. But if there's none, then they're going to have a problem. But this is going to be a very hard sort of task to do, because at the end of the day, the act or the relevant legislation seems to have been complied with. There was a meeting that was held by the royal family, and the name was submitted or was nominated, and that particular name has been given to the president. The president is given that particular signature. I do not think that the president would go to this extent and comply with this legislation if the president was not satisfied that everything is accordant with the relevant legislation.
But the family factions are not satisfied, and they could be adamant to take it further and ensure that that certificate is not handed over, although that, of course, is just the loss aspect, and he's already been recognized by the AmaZulu nation as the rightful heir to the throne. There are still factions contesting. I mean, we saw last week a coronation taking place. So when it comes to the legal substance that the families, the factions are putting on paper to ensure that they make it to court and voice their argument, what sort of argument are they looking at there? Because as you make mention of, President Cyril Ramaphosa has already declared the rightful heir to the throne.
Firstly, whether they stop the handing over of the certificate, it has no significance whatsoever. At the end of the day, according to the legal framework, which is the Coronation and Traditional Leadership Act, you have someone that has been recognized as a seal and the king of Amazon. So on that one, I don't think they're going to get any reprieve. However, if they were to say, how do we fight this particular manner, or what are the irregularities that could have been there that may lead to the withdrawal of the recognition, they would have to say, let's look at what constitutes the royal family. Are the members that attended that particular meeting real members of the royal family? Was it constituted in such a manner that extensive consultation was done? When the name of MisuZulu was being raised and proposed upon, was it proposed by the appropriate person? Did it get the majority in which it deserves? Was everyone or the majority of the members that attended that particular meeting in unison and agreed that this is the name that must be nominated? Were all the nitty-gritties in terms of administrative compliance is done in terms of the signatures? Are they proper signatures? Was the handing over of that particular nomination to the office of the president and also the Premier of KwaZulu-Natal done in a proper manner? So what you're basically doing is you are carrying a checklist and you're saying, according to this particular the legislative framework, this must be done. That is one part of it. The other part of it is, how do you conduct these part of meetings when it comes to the royal custom or the royal way of doing things when nominating a king? Remember, that is not codified anyway. There's no piece of legislation that tells us that when the Zulu royal family sits down and holds the meeting, this is what is going to happen. It is purely done, or is, let's call it a family secret for a lack of a better word. Now, if you are not going to be able to expose the inconsistencies in terms of the particular part of the law, you are going to have a memo task to mountain to climb. Because at the end of the day, you can't prove what the court would want you to prove. The court will simply say, show me the inconsistencies that have taken place that warrant that this particular individual that has been nominated was nominated incorrect. If you can't do that, then I can't grant you this order, because at the end of the day, whoever that alleges must prove. So if you come to court and you say, this is not a king that is legitimate, show me reasons where there's been instances where there's been non-compliance, and maybe I'll come to your reprieve and grant you that particular order.
Queen Mantfombi named Prince at the time, MisuZulu, King MisuZulu, the next in line should anything happen to her, which speaks to perhaps a conversation around the validity and significance of having a will when it can be contested.
Now, let's focus on the content of that particular will. If I remember correctly, it did not say I'm taking away your discretionary powers as a Zulu royal family. It simply says, if it were to me, this is the name that I would recommend, as I see that this is the appropriate individual that would be able to protect the legacy and also to protect the throne. However, if you have some other names that are there, you are free as a Zulu royal family to come and discuss any other name other than the name of MisuZulu. So the discretionary powers are not taken away. The king was not chosen by the will. Whether the will existed or it didn't exist, at the end of the day, that Zulu royal family meeting ought to have happened as it was done, and the name was going to emerge from that particular family. It may have suggested a certain name. However, at the end of the day, the discretionary powers of the Zulu royal family members was not taken away by that will. So whether you say it's a valid will or it is not a valid will, it will only deal with your movable and immovable properties and other matrimonial properties that are there. That's the only thing it's going to affect. When it comes to the throne, it's a totally different set of facts, and the merits are totally different as to what the court is going to look at the end of the day.
How would this matter have been considered were it in a different court, a traditional court, as opposed to the Pietermaritzburg High Court?
The focus would have been simply on the Zulu royal customs. The most important question would have been, how would have our forefathers chosen the next king? How is that done? Are there certain signs which must be there, either through forces of nature, or are there certain elders who are supposed to sit down and select? Did anyone hear the late king, Mpumelelo, maybe whisper a certain name and saying, this is the person in which I think has certain qualities? So you take away the investigative elements or the presiding officer's elements that you would find in a normal court of law, and you attach those to a traditional court and say, traditionally, through our customs, how do we make sure that we select the next king that is appropriate? Let's use those processes so that we are able to emerge with the name that would be there. Another thing that I'd like to add is that If you look at the way in which these two courts would have sat, when you go into traditional court, it is more of a mediation type of role that rather than the accusatorial type of role when it comes to our traditional courts, to our normal courts. The traditional courts will then say, we want at the end of the day to merge with a solution which is going to be amenable to everyone. We're trying to mediate the matter as far as we can, not moving away from our customs and the way of life. So if we can be able to find each other, we even call it in Zulu, that's what we want at the end of the day, rather than the winner takes all type of advantage or manner as we would find it in our modern courts. So on that one, at the end of the day, the elders would have said, we do not want anyone to leave this particular crawl not being happy or not being accommodated in terms of their views, but we're not going to deviate from our customs and traditions that are there that we've used over time.
Yeah. Thank you so much for your time and that analysis, the legal analyst, Mpumelelo Zikalala, speaking to the matters of the Pietermaritzburg High Court striking off the roll and application to interdict the traditional coronation of King MisuZulu. In other news,